Before I was mic'd up this morning, I had proposed to stand up and invite, this augments my voice, and invite us to proceed under Chatham House rules, so we could have a free discussion and perhaps exchange ideas in a safe forum. I am told that this is being beamed live on the internet, and therefore there is no purpose at all to me suggesting we have this under Chatham House rules, whatever they might be. And so what I'm going to try and do, and what Sandra and Michael will also try and do, is be as candid as possible with you. We won't be able to give you legal advice on precise issues that have arisen in your case or that have arisen in your friends' cases or practices, but we can certainly answer, as far as we're able, general questions. And if we can't answer those questions in this forum, which is obviously public, please do come and see us. We're having a session this afternoon, as we did yesterday, 2 o'clock until 3:30. You can come, you can be anonymous, you can ask legal questions. I'm a regulatory lawyer. I'll tell you what that means in a moment. Michael is a family lawyer. Sandra is a criminal lawyer. We will also have private client lawyers here. I hope we'll have someone from our reputation management team as well. But collectively, we have some answers. The law does not and absolutely cannot provide all the answers to the issues that will arise in your practices and in your clients' lives. I don't know who is sitting in the room today and what the makeup of the audience is. Can I first say thank you very much for coming. It's great that there are people here that want to come and listen to lawyers. It's a rare thing. Second, it would be helpful to know what the makeup of the room is, certainly from my perspective. So, as a regulatory lawyer, as the name suggests, I advise professionals in the field of regulation. Regulation sits somewhere between the criminal law and the civil law. It's a grey area, and there's an hilarious joke in my firm, which is that the regulatory team gets all of the work that nobody else wants. And that's sort of true in many ways, because if it's not a strictly criminal issue, it's not a civil issue, it tends to fall within my sphere. And so as a regulatory lawyer, I'm predominantly concerned, but not exclusively, predominantly concerned with those individuals who are regulated as an individual practitioner, or whose practices are regulated, or whose practices or those individuals working in them will potentially come under the scrutiny of other regulators. My goodness, what do I mean by that? Are you BACP registered? Are you UKCP registered? Are you BPC registered? Were you once ICO registered? In the future, under GDPR, we'll come on to that in a minute, will you come under the auspices of the reach of that new regime? Any of those things mean that you are potentially in the regulated sector, not in a legal definition of the regulated sector, but the regulation affects you and your practice. And that's really what I'm going to be talking to you a little bit about today. This is the agenda. I'm obviously going first. I'm going to be talking for about half an hour, 45 minutes. Sandra is going to be talking to you next from a criminal perspective, so she's going to give you a day in the life. Her talk is going to be a lot less dense. Mine is quite law-y. I'm going to try and make it not too law-y, because law is really quite boring, other than if you're a lawyer. And then Michael is going to follow up and round up at the end with his perspective, not from a practitioner's point of view so much, but more what it's like as a family lawyer working with addicts. And also working with therapists, because so much and so many of our clients have addiction issues, have trauma issues, have attachment issues, have issues that require us very often to refer them on to therapists. And in fact, lots of our clients are referred to us from therapists. So the interface between our profession and yours is great, and I think it's probably increasing. So there will be question and answer at the end, as I've mentioned, but if you're not happy to discuss issues in public, please come and see us a little bit later on. Could I ask if anyone here is regulated by any of those bodies that I've mentioned, or has had that kind of interface? Okay. And of those that aren't, Of course.
Would you cover the other side as well? Because as a regulated person,
Yes.
I have been exposed to, say, stalkers, or as an expert witness, I get clients who don't like what I say or disagree, and then they go through this path to
Yes.
us as professionals. And I wonder whether there is, as well, that part in your presentation, or maybe that's a private conversation.
Yes, I mean, I think both in answer to your question. So I'm going to be touching a little upon, quite a lot on, the way that those that are regulated are dealt with by the professional organisations, the regulators that look after them. And those are really the pitfalls to be looking out in your practice if you're regulated, but also if you're not, because the standards set by those regulators are very good benchmarks for all individuals and practitioners to comply with, to maintain reputation, to maintain high standards and good patient care. So I'm going to be dealing with probably both of those, but do ask questions either now or at the end, or come and see us. So a little bit about me, and I don't have many anecdotes, it's not the sort of lawyer I am, but a little bit about me so that you understand how I've arrived here. I was a criminal lawyer, and I defended very serious criminals against very serious allegations for a number of years at the bar. And then I left and came in-house to Kingsley Napoli, and I have looked after regulated professionals for a number of years. I have a very niche practice in looking after analysts, psychotherapists, counselling psychotherapists, counsellors, the list goes on, talking professionals, as I would call them. And I advise them both in issues that affect their practice when there's not a complaint. How do I become compliant with this? What do I do with this piece of confidential information? But I specialise in advising practitioners when things go wrong. I've had a complaint. I have lost my USB stick. More usually, I've had a complaint. Please help. The complaint is specious. The complaint is not true. I'm not being dealt with fairly. My reputation is at risk. And so it's really from that standpoint that I am standing here today to tell you a little bit about my experiences and those pinch points where you might want to finesse and think about your practice. I've also always had a very strong sense of injustice, and I cannot stand when big, weighty organisations deal with small individuals or small corporates, small entities in an unfair way. And that is how I came to looking after practitioners such as yourselves, and certainly those who are regulated in the room. A colleague of mine went on maternity leave, and she handed me a case. I knew nothing about psychoanalysts. He is still a very well-known psychoanalyst, and he had a rag bag of allegations against him. Some were tremendously serious, crossing boundaries, touching. Some were totally preposterous. You were late for a session. You spoke in a raised tone. Things like that, really a rag bag of stuff. His regulator, we're not Chatham House, but I shall tell you who it was. It was the BPC, had a particular scheme that meant that he was not allowed to know what the case was against him. He wasn't allowed a lawyer in the hearing. This was a proper hearing, so they called it an inquiry, but it's not. It's a trial. There are witnesses. There's a case against you. Your reputation is very much at stake, and so is your livelihood. He contested much of what the witnesses had said against him, but he was only allowed to cross-question, to cross-examine through the chair. So he had to write his questions down and pass them to the chair, and he had 10 minutes, and this was the way that the scheme ran. Now, if you had a list of things that regulatory lawyers kept to demonstrate and that incorporated those aspects of what a fair procedure was, that procedure had none of them. So I get this case. They had been through this hearing, they'd lost, they'd appealed, they'd lost, and then they put in a challenge to the High Court because the BPC are amenable, which means they're subject to the jurisdiction of the High Court. And eventually the High Court the High Court didn't have to hear the case because the BPC capitulated, and the case was completely dropped, and as a result of that case, the BPC introduced a new scheme. They consulted on some new rules. They now allow lawyers. We now have allegations. And this is an absolute victory. No, it's not a Pyrrhic victory. It's not about lawyers puffing themselves up. It's about you professionals. This could have happened to me or someone else I know. if you're a professional person and you subscribe to a scheme and you're susceptible to a complaint, you must be dealt with fairly. Wow, I'm still on the first slide. I'm going to carry on, but that's how I arrived in looking after professionals such as yourselves, and then work has continued to build based upon that kind of foundation. So that's where we are. Disclaimer, sorry for the cheesy slides. I had prepared some other slides, and we have new marketing rules, and so they've all had to be sort of copyright proofed, and so forgive me. Disclaimer, like all good lawyers, I start with a disclaimer. I'm not an addict, I don't think, not a serious one. I'm not a therapist. I've been in therapy for years, so I'm almost qualified to stand up here. I know a little bit about your work. I do not know everything, and nor do I know everything about all of these areas of law that I'm going to talk to you about, so I shall do my best. You might be wondering why you're here, if I can't tick any of those boxes. I hope you're here because you're interested in learning about the interface between law and therapy. And we had an interesting Q&A yesterday on a number of issues that are raised in this forum. So, for example, confidentiality. How do we reassure our clients that their data won't be leaked? How porous is the professional relationship once you start to engage with families and so on? So there are opportunities for that interface, and really that's what I hope to illuminate you a little bit more about. I've dealt with what is regulation. It's not just red tape. It affects all professional people, and if you have been the subject of a complaint, then you will know very well how it can affect you. What is the difference between statutory and non-statutory regulation? Forgive me if this is really well known, and if everyone nods their heads, I'm just going to move on. No, okay. In the UK, there are, broadly speaking, two types of regulation. There are statutory or chartered bodies who are set up by the government, generally speaking, and they require a number of things. The first is that if you want to enter into one of those professions which is statutorily regulated, you must register with that regulator. Obvious examples are the GMC, architects, nurses, paramedics, the list goes on. So it is. And the second aspect of statutory regulation is that there's something called protection of title. Yes, so you're all nodding. So you do know this. So this is really the point. That's the main difference. I'm going to shake at the back. So protection of title means that if I was a doctor and I registered with the GMC and I touched my patient inappropriately and I was struck off the GMC register, I couldn't pop up a website the next day saying that I was a doctor. That's a criminal offence. The GMC would prosecute me. I don't think it's imprisonable, but I would still have a criminal record and I'd have to pay a fine. That title is protected. And in respect of some professions, so are the activities that fall under the umbrella of that professional's work. So with nursing, the work to do with phlebotomy or treating patients at the bedside, all of these activities you're not allowed to do, or various of those activities you're not allowed to do unless you are registered. So it's mandatory and title is protected. Psychoanalysts, psychotherapists, counsellors and various other of these talking professional professions are not statutorily regulated. And there is something called voluntary regulation. Again, some of you will know this, and there are positive aspects to regulation. I'll come on to it in a moment. But insofar as voluntary regulation is concerned, the greatest difficulty with it, in my view, is that those that sign up to it are not aware of what they're signing up to. That's it. That's the biggest issue. So when you become a therapist and you've been through all of your years of training and you eventually become an associate or a fellow of whichever institute, and you gleefully sign your registration form for BACP or BPC, what you don't realise is that you're entering into a contract. It's a legal contract, and all of those terms are enforceable against you. And those terms confer some benefits to you, and it's right to say there are some benefits, and we heard some really positive stories, particularly yesterday, about the benefits of the ethics hotline, for example, of the BACP, for which they are to be commended. Absolutely, because that is, in my view, the purpose of a regulator. Let's ensure compliance by teaching and learning and sharing, not beating with a stick. So when you sign the contract, many, not all, but many don't appreciate that the demerits, or rather the consequences of having signed up, are that when there is a complaint, you cannot leave the register. You can't say, I want to resign. That complaints process has to be seen through to its bitter end, which is fine if the complaint has merit and if you're treated fairly. It's not fine if it's specious and if you're not treated fairly. Because although you will lose your registration, you can still practice. That's not the point. Because the contract permits those outcomes to be publicly declared. They will be in the BPC magazine. They will be on the website. People will be talking about them. So it's a reputational issue. So I suppose that's my beef, if I have one, with voluntary regulation, is that if it's not necessary for the purposes of the continuation of your professional life, it's a balancing exercise between finding what the merits are when there is a potential demerit. Now, the merits are this: it galvanises the profession. It allows you to, as a kite mark, cite your compliance with these heightened standards, and all of that is terribly important. But we've missed a trick in some ways, because these professions were going to be statutorily regulated, coming under the auspices of the HCPC or one of those other regulators that has been doing this well. And I announce my bias, as it were, because we act for the HCPC, but they do it well, would mean that those protections would be afforded automatically to registrants. Anyway, I digress. What I have tried to do here is select some, not all, it's not comprehensive, but select some issues which can help regulated and non-regulated practitioners achieve regulatory compliance. These are not exhaustive. I conducted a survey in the office, very, very technical, and these are the ones that we came up with, and I'm going to deal in short order with all four of those areas. There are others, and if you have questions about others, please do ask. The first topic, and it's a whopper, is confidentiality. It's difficult to know where to start, but I'm going to talk about the importance of maintaining confidentiality, and this is the really interesting bit, when you can breach it. Because there will be circumstances where it is appropriate to use your judgment as a practitioner to say, I've got to go outside this contract of confidentiality, I have got to tell someone. And those are very, very difficult judgment calls to make, and you have to be courageous to make those. And then I'm also going to be talking about the GDPR. Another disclaimer, I'm not a data protection specialist. I'm a regulatory lawyer. I do data protection. I know much more about the DPA, the Data Protection Act, than I do about GDPR, but I will try. So I do advise on this, but we have a specialist team in the firm that deal with this. So I have some answers, but please, if they're very technical questions, I'm going to pass you on, probably to Michael, he won't mind. So the starting point is well known to everyone, I would assume, that as a therapist, as an analyst, anything said to you in therapy, and anything that you write down, anything you're told, any document created, passed to you, sent out, has a confidential character to it. Seems a very simple proposition, so that's the starting point. The BACP ethical framework and the UKCP framework reiterate these, and this case has confirmed that it extends to therapists. A footnote, and it's a bit of an aside, and I was surprised when I looked into this issue for a case that I did recently. In the BACP and the UKCP, and indeed the BPC ethical codes, there is no express requirement to keep notes. The BACP has a passing reference to keeping notes as are appropriate in the circumstances, but there is no granular stipulation that tells you that it is required, and if it is, what is required. And so the keeping of notes by way of an aide-memoire or for any other particular purpose for a referring clinician is really a matter of judgment for you. There are risks in not keeping notes. I don't know how any therapist, I don't know how any professional can keep all of that information in their heads. But once something is committed to writing, the risks associated with keeping it safe are very, very real. And in this new world of GDPR are dangerously real. So it's just in passing, really. So it's usually unproblematic. We know what's confidential and we know we have to keep it confidential. Why? Why does it matter? Three broad reasons. If you don't keep data confidential that needs to be confidential, for example, I've had clients that have been working in multidisciplinary practices and they've dipped into the patient notes for their friends, that kind of thing. Doesn't apply. I'm telling you for interest, not because this is going to happen to you. There is no offence, a criminal offence of hacking, so that's not a good thing to do. And the ICO also prosecute offences under the Data Protection Act, which are criminal offences and will leave you with a criminal record. So there are serious criminal offences to not dealing with data properly. The CPS, when they're looking, or the ICO, when they're looking at whether to prosecute or bring proceedings for criminal offences, have very strict tests about when they can bring charges. There has to be enough evidence, and it has to be in the public interest. So prosecutions are really rare. Criminal. Civil, that means being sued. There are a range of different torts that can be committed under the Human Rights Act, Article 8, protection of your private life, family life, and so on. So, and there's also the civil right of confidentiality. So if you're not keeping someone's data confidential, you might be sued. It's nasty, it's costly, but you're normally insured. The case is normally settled, so it's quite private. Why am I telling you this? Not so for regulatory. And this is my beef, back to my beef. If the regulator hears of a breach of confidentiality, they don't apply this two-stage test that the CPS apply. They don't go through the evidential test and the public interest test. They say, there's been a complaint, I'll investigate it. The investigating consists of them taking the complaint and sending it to you and saying, here's the allegation. Deal with it. So it's very serious, and of course the outcomes are public. So unlike criminal and civil, the outcomes for practitioners can really be much worse. Each of the regulators has a clause about confidentiality. They're broadly the same, and they require you to keep all of your data confidential, as we've discussed. This is the interesting bit. Bear with me. The exceptions to confidentiality. I don't know if anyone has had experience or have ever had discussions about cases in supervision where a client has said to you, I feel like perhaps committing suicide, or you observe in a child, if you treat children, neglect, or you are told of abuse, either historic or suspected in the future. Those are really difficult situations. As a lawyer, what I am required to do is to protect life and limb. That's it. So I have something called privilege, which is a bit like confidentiality, and I mustn't breach that unless I have a reasonable belief, a real and honest belief that something imminently is going to happen that's going to very seriously harm my patient or my client or a third party. Your discretionary ability, your ability to make a judgment about breaching confidentiality is really similar, and so we'll come on to that. So there are exceptions. Confidentiality exists, but when can you breach it? You must breach it if the court tells you to. You may or may not have had this. It doesn't happen often, but it does happen. Just be careful you're disclosing the right thing. Make a note. It's really good practice to tell your clients, your patients as well. And if required by law, all of the statutory regulators can compel you. If you get a letter from the GMC and it says hand it over, take legal advice, brackets. But the voluntary regulators don't have that power. If the BACP write to you and say hand it over, say, if you want to. Of course, if you want to comply, try and get consent, and please see a lawyer. But they don't have those powers like the statutory regulators do. That's mandatory. Discretionary disclosure. What's that? Oh. Gone the wrong way, hold on. Discretionary disclosure, I've divided up under two headings. One, harm, that's the scenario that I talked about as a lawyer when I really feel that something terrible is going to happen, something bad is afoot, my client is actually going to jump off a building. Confidentiality, put it to one side. And this is the proposed test, and it comes from case law, so a body of case law where judges have looked at cases and decided that this really is what practitioners should be thinking about. Does the release of information to protect the interests of a third party exceptionally prevail both over the duty of confidence owed to the patient and the public interest in a confidential health and social care service? And that could be because the patient needs protecting, third parties need protecting, or a civil wrong or a crime is about to take place, or in fact in certain circumstances has taken place. So there are a range of relevant considerations when you're thinking about making this sort of disclosure. Think about the nature and the extent of the disclosure. Think about who you are going to tell. There needs to be an identifiable person who can do something with this information. So if, for example, your patient, your client, was due to attend the probation office or had a bail to return date and hadn't complied with that, or should have turned up at court and hadn't, would that be adequate for you to consider contacting his probation officer or contacting the court? I would suggest no. But if your client says, as in my previous example, I'm going to take that knife that I told you about and I'm going to drink 3 bottles of whiskey, and I am going to do it, and you've known this client for a long time and you're pretty sure they mean it, then what? Is it okay professionally to do nothing, or should you exercise your judgment? Do you need to be courageous? Do you need to take a step to breach that patient's confidentiality? Who are you going to tell? Are you going to go straight to the police? Are you going to tell the person who's the intended victim? What do you do in those circumstances? And I would suggest someone in an official position is better. And in that scenario, I would phone the police. But you may take a different course. You must also think about the likelihood of your disclosure being able to avert the harm. If no one is going to be able to do anything about it, there's probably not much point you making a disclosure. So that's discretionary disclosure for harm. Hold on, the slides are not moving. Yes.
Are you going to cover emails? So I get
In what way?
Email information sent to me by doctors, and they often get sent to me maybe like wrongly. I actually gone to another therapist.
Yes.
Where does that stand?
So you're in receipt of an email which wasn't intended for you,
Yeah.
which contains personal information.
Yeah.
So you only obtain that information if you requested it.
Yeah.
And what you must do with it is delete it permanently and notify the sender that they have sent it in error. You may have additional obligations. We need to think about it a little more to make a report to the Information Commissioner, particularly in the new GDPR world that we're going to be living in. But you, as the unintended recipient, are not in possession of it because you didn't garner it, you didn't procure it, it just arrived. So you delete it permanently and you notify the other person and then think about whether there are any ongoing obligations. And I would go on the ICO website and I would say, unintended, I would type that in and you'll get the answer as to whether you should be making a report to the Information Commissioner.
What happens if you do it yourself? I mean, it happened to me and I did it by accident.
Yes.
Luckily, called the client and got to him, because unfortunately he gave me two email addresses.
Yes.
You know, his work email address had his surname, and his private email address had his Christian name, and I got it wrong. It was late in the day, and I sent it to somebody else, you know, like actually, and also I called that person and delete it quickly, and you know, call him up there. You know, and I was shitting some bricks for the first money.
No, it's a really horrible feeling. It's a horrible feeling.
Exactly. And it, you know, and I thought, shit, you know, it's the first time I've actually broken someone's confidentiality.
Yes.
And it was, you know, talking to the client.
Are you registered with the ICAAD?
No, with the BACP.
Yes.
And I'm sort of American bodies as well.
Okay. Okay. So in answer to
luckily it went no further.
the Information Commission's Office have a threshold of suggested reporting.
Right.
But presently there's no mandatory requirement to report yourself. And you're not registered with them in any event.
Right.
Yeah, but that's the potential commission of a criminal offence. But of course you would have the offences under Section 55 of the Data Protection Act have to be committed recklessly or knowingly. And if it was completely inadvertent, if you were sent the wrong address and there's been a transposition, it's only happened once, one would hope that proportionality would come to play. I mean, all businesses have data breaches. And I'll come on to it in a moment when we talk about the GDPR. But what is required under GDPR is that you have a process for dealing with those breaches. So you have a process for obtaining and keeping data safe and deleting it. This is required under DPA, but it's heightened now, and that when there is a breach, you go through a particular formula for dealing with it, and you know, therefore, what should be done when there's particular levels of breaches.
Well, and I know the person to come to. So thank you very much. I'm sorry about these.
No, not at all. The second category of discretionary disclosure is crime. And this comes from a case in which the judge made this remark. Once a serious allegation is made, particularly one criminal in nature such as abuse, it cannot be ignored. A child cannot be sheltered from the consequences of the information disclosed, and the person to whom the confidences have been made or suggested must give the child a truthful description of the likely outcome. This is really, really difficult. So, again, there are no hard and fast rules, but broadly speaking, the more serious the offence that will or potentially has been committed, the more likely that you may wish, it's only a wish, it's not a requirement, to consider whether you need to breach confidentiality. So things that might be in that category: rape, kidnap, arson, serious offences, things that might not be: theft, assault, damage to property, and so on. So confidence can be breached, for example, if you have strong grounds to suspect that a child is being abused. Here we are, data protection, everybody's favourite subject. I'm going to go straight on to what is new, just looking at the time. If you're familiar with the DPA, the Data Protection Act, if your firm is, if you are, if your organisation is, not an awful lot has changed, and I caveat that with there have been some significant changes, but there are some key changes that you need to be aware of. There is, without doubt, greater accountability for the data controller or the data processor. Now is not the time to deal with those two different categories of people, but if you have personal data, and the definition of personal data, courtesy of the UKCP, is there. If you have personal data, you need to make sure that you understand your lawful basis for processing it. It is highly likely that as a practitioner, your lawful basis for processing personal data will be consent. If that's right, a number of things need to happen. Your consenting needs to be reviewed, I would wager. Your consenting process. What is required is a very granular, very clear, very specific and unambiguous consenting process that must be separate to your terms and conditions. So that is required in the first instance, and you must clearly identify what your lawful basis for processing is, because if it is consent, the data subject has greater rights. to deletion, to access, and so on. So it's really important that you identify that and you make it clear. Second, as I've already alluded to, you ought to, I suggest, revisit, finesse and improve by looking at the ICA website, if you don't have access to lawyers, your process for investigating and reporting breaches. You must have one. So go onto the ICA website. It's the best thing I can suggest. You should also perhaps know that it is far easier under this scheme for individuals to access their personal data, and it's far more difficult for you to comply. So those subject access requests that you used to get and have 40 days, it's now 30. You don't get a fee for it. You used to have a minimum fee of £10. That's all gone. So it's more burdensome for those people that process and hold personal data. And as you've probably all understood and heard in the news, it's the headline hitting staff larger penalties for non-compliance. Getting ready for GDPR, just 3 really high-level suggestions for you. Audit. So carry out an exercise to see what data you've got, where you store personal data, and as I said before, find the lawful basis for your holding of it. Cleanse. It's really satisfying. Go through all of your emails. Delete. If you don't have a purpose for holding that data anymore, by the 25th, I think it is, of May, it needs to go. Nobody is going to be compliant on the 25th of May. No firm, no law firm, no individual, but you need, I suggest, to be working towards compliance, so to have a route map in place so that very soon thereafter you will be close, if not having achieved compliance. And then my proposal is that you draft some new data handling policies. So I'll come on to client contracts just in a moment, which is also the last topic that I'll talk about. When you're looking at your client contracts and your terms and conditions, it might be worth looking in there about your confidentiality provisions, your privacy notices. What are you telling your clients about what data you're obtaining from them, where you're going to put it, what you're going to use it for, and when you're going to delete it? Those privacy notices are, again, under the GDPR scheme, really crucial. Also, if you operate in more than one EU member state, so if you send data within the EU, either within or without your organisation, there are specific requirements to identify your lead or your supervisory, what do they call it? Supervisory authority, I think it is. And there are particular issues that follow from sending data, as there were under DPA, outside of the EU. So it's an audit, it's a cleanse, and then it's drafting new data protection policies. I'm going to deal with ethical boundaries. How long have I got, Michael? Am I right? I'm going to deal with ethical boundaries and then in 30 seconds, client contracts. So in terms of ethical boundaries, those that are regulated will be abiding by their ethical codes if you can get to the bottom of them. Many of them are very, very complicated, are multi-layered and reasonably complicated, and I wager that your own moral compass will probably guide you as well as those quite densely drafted policies will. And it's also right to recognise that those policies can't cover every single ethical scenario that is going to come up, so you are going to be looking to exercise your judgment, and as I've said already, act courageously. I conducted another survey with Sian in the office, and Sian and I came up with these 5 sort of key flashpoints, issues that have arisen in maybe in my last 10 cases looking after analysts and therapists, in some, all, or many of them. I'm going to just deal in short order with the last 3. I'm going to dwell on referral fees, but I'm also going to look shortly at self-referral and shortly at supervision. I know this is quite sensitive, and so I'm going to try and deal with it quite sensitively and neutrally. And I'm going to deal with it from the regulatory perspective. Sandra's going to hop over here and tell you a little bit about it from the criminal perspective. And please stop me. If people, I'm not in the industry, if people have particular views or don't agree or you want me to clarify, I'll just start. the referral fees that I'm talking about are those that individual clinicians or clinics receive from perhaps other organisations that they're referring patients onto. So I'm not talking about those triaging organisations that are non-medical, non-qualified, non-clinicians that are taking money contrary to the law. I'm talking about fees that are passed between institutions for referring patients on. It's really common in this industry, and it is in contrast to other industries where it's impermissible and unlawful. So that's really my interest in this subject. So as a barrister and now a solicitor, I'm not allowed to take them. It's proscribed. Dentists aren't allowed to take them. And the reasons for that are fairly obvious in some ways and are counterintuitive in others. But that's the position of other professionals, that they're impermissible. And so I looked at the law. And for some clients, I've been advising them, and I've had cause to go back and look at the law and see what is the legal position. Is it impermissible as a regulatory piece? Is it regulatorily? Is that a word? Impermissible? No, it's not. So as a starting point for those that are engaged in this industry and take or receive, or it's not impermissible so far as the regulators are concerned. There's no bright line, there's no rule that proscribes it. So the UKCP have no express prohibition. They say this, and these are the reasons why there are perhaps tensions around this issue. They say that referrals must be in the best interest of the client, and they must be made in an informed and professional way. And so that's where we might come into thinking about conflict issues and about acting in the client's best interest and transparency when there is a financial incentive to refer that may be absolutely in the client's interest, but it may not. So that's what the UKCP say about it. The BACP, again, there's no express prohibition. They also say, of course, that referrals must be in the best interest of the client, and that you must be honest and straightforward and accountable in financial matters concerning clients, and that conflicts are best avoided. So whilst there's no bright line, there are clauses that if a regulator really wanted to get stuck into this issue, they might. They haven't yet. This hasn't come, to the best of my knowledge, to the attention of the regulators. They haven't issued any guidance about it. And it seems to me that that's the first thing that needs to happen, that if the regulators consider that this is inappropriate and unacceptable, as the Solicitors Authority has issued guidance to solicitors about non-disclosure agreements. You've probably heard, in the news about Trump and those sorts of agreements now. We are explicitly told as lawyers, you cannot oust legal rights, stop drafting NDAs to prevent disclosure to the police. If the regulators want to stop this, they should tell us that that's what they want to do. So that's what I tell my clients, that they haven't issued any guidance yet, but we want to start thinking about the ethical issues that arise. Sorry, the slide things aren't working, so I'm just doing it manually. Sandra is going to tell you a little bit about how the criminal law might approach referral fees. Is that all right? Yes. Yes.
You mentioned the UKCP and so on as regulatory.
Yes.
But clinical psychologists are chartered by the
HCPC.
Is there any comment about the fees?
I will have a look. Just when Michael's talking, I'll have a look. But from memory, their SCP, their Standards of Conduct, Performance and Ethics, don't proscribe them. I don't remember them issuing any guidance about it or any statements, but I can check. And I certainly haven't heard, as I say, because we act for them, any cases that we've had about referral fees. So I don't think it's an issue that they have grappled with yet. I think they've got other things on their plate at the moment with the migration of the social workers, perhaps. But I'll have a look, perhaps when Sandra's talking. Okay.
Thank you. So I'm just popping in at this bit, really, just to speak briefly about bribery, because it's perhaps something that you wouldn't think of as relevant to your areas of practice. And we are certainly not talking about bags of money with swag written on it, brought to your office. But what we are talking about is a relationship that you build with a client over a period of time, during which you get to know that person, and during which, in the normal discourse, there is an exchange of something that might look like friendship, something that might look like civility, something that might look like kindness, and just a kind of an opportunity to stop and think about the ways in which, from your perspective, this is an area to be really, really careful about, because the offences of bribery that I deal with corporates, with individuals and small business people, are as relevant to you because you are a small business, and therefore this legislation applies to you also. The activity that it prescribes has to do with an activity connected to a business and an activity performed in the course of a person's employment. And of course you are all self-employed or employed by an organisation. And so when you are performing those functions, if the activity is one which you are expected to perform in good faith, I think tick for therapists, perform impartially, tick for therapists, and where you are in a position of trust by virtue of performing it, I think again, tick for therapists, then these rules apply to you. And so in your context, perhaps we're talking about, and rather go through all the legislative detail, we're talking about the part of the conversation, either beginning or end of a session, that says, oh, actually, I can't go to the theatre tonight. I've got these tickets. Would you like them? Maybe it's more subtle, and there is a disconnect between the favour that is done before, yes, I'm a plumber, I can sort that out while I'm here after my session, to the discussion when you have to provide that report for a court or another tribunal, where somebody says, well, actually, I'm not quite happy with the way that you've described that. Can we talk about it? And whether you feel that you are able still to provide information, to provide that assessment to that other individual, the court or that individual client, in a way that's completely impartial. And so the decisions that we make very early on in a relationship with a client, the way that we describe that, the way that we document those boundaries, how you deal with that first offer of assistance becomes really important and is your safeguard for preventing these rules being ones that bite. They are important. They are often prosecuted by the SFO, and as you probably know, the SFO is very rabid at the moment. There's about to be a change perhaps in direction that may change the mood music, but I doubt it. And looking for opportunities to make sure that these pieces of legislation are embedded in our psyche, because they involve activity in the UK and outside the UK. It can be direct or indirect, so a favour done or offered by somebody else to somebody else. So it doesn't have to be direct to you, it could be to somebody connected with you. But these are just all things, and the reason we wanted to include it was just to alert you, to have your antennae up for things which seem out of the norm, may feel innocuous at the start, but which can progress to more difficult areas. I think that's probably the best way to deal with it, given that we're short of time. But if you have more specific questions about how the legislation applies, I can deal with those either later or at the question and answer. Is that okay?
Yeah, thank you. Actually, I'm going to cut short my presentation. I was going to briefly talk about self-referrals, when you should tell your regulator about things you've done. I'm not going to do that now. If you want to ask me about it, that's what I was going to tell you. And I was also going to talk about supervision, but I can tell you later. I can come back after Michael and Sandra. It's past, so I think I will sit down. I've been speaking for a long time, and I will leave you in Sandra's hands. Sandra, I know you've just sat down, and I can deal with questions at the end. Thank you so much for your patience and listening. Thank you. Sandra, sorry.
It's okay, it's fine. I'm going to take this, to make sure it's working, as shortly as possible. So my general message is, as a criminal litigation expert, is I love therapists. A client who is in therapy, thinking about therapy, has finished therapy, is helpful to me. It makes my job much, much more bearable. And so I wanted really to say, welcome with open arms. I know that some people think about there being a disconnect. In my world, there absolutely isn't, because the reality is the bit I like dealing with are the facts, the law, how to apply them, how to get the best results. The murky insides of my client's head is exactly where I do not want to be. But I need to have the product from it. I need to know what the motivation is, what the behaviour was, so that I can put that in this context in front of a court, in front of a police officer or other investigator, in a way that explains it and in some way either manages or diminishes their culpability, if that is the appropriate thing to do. And so I just wanted to touch briefly on the range of areas where I might use a therapist, making it absolutely clear that I definitely want to work with you. And so firstly, and again, same rider, sorry about the cheesy photographs, copyright, all of that. Drugs and alcohol. I mean, I think that the issues there are probably quite obvious to you, but from my perspective, really thinking about those blurred lines and the level of culpability that may exist for my client. For instance, prescribed medication is going to give me some opportunity to say something about my client's level of responsibility. Illicit drugs or excess alcohol, usually no, except there are some circumstances where it becomes relevant. So for instance, I've dealt with a young man who was out with a friend. They were having a complete cocktail of drugs that they'd been taken. I found out that acid is now popular again. You probably knew that before I did. But as a result of that cocktail of drugs, he stabbed his friend, no question that they're friends, in the chest, resulting in a very serious injury. He was originally charged with attempted murder, and that was explained because in part the drug that he had taken prevented his level of culpability for that very serious offence, which required a specific intent to kill somebody else. And so your explanation, and in this case there was an assessment regarding his use of violence and his general personality type and the specific use of violence in this occasion, and that enabled us to explain that he was not a risk for the future, and that actually his level of culpability in respect of this incident was somehow diminished. And so, again, your information regarding how and why is really, really important. The next issue is with gambling and related aggression. Not that the two go together, but they're the two separate things. And so it can lead to offences of fraud, embezzlement, theft, and of course then with violence and aggression, a really big area in terms of the work I do, in terms of thinking about domestic abuse, harassment, that kind of client who's harassing you before you've taken them on. I'm going, I just need to find somebody before you sign an engagement letter even to pass you on to, so I can manage and provide you with the help that you need. But that issue about anger management and control, they can be really important for me and my work in terms of assessing future risk for clients. In terms of therapists, the largest area where I use therapists is sex by far. And the session that we had in this room just before here was so helpful for me. But there is such a range of behaviour that I end up dealing with from a criminal perspective, where a psychosexual therapist assists me. And it's the first thing I do. It's something I establish in the first appointment if they're not already in therapy regarding this. If there is a police investigation regarding your sexual conduct, there is an issue that needs therapy. Doesn't matter whether you're guilty or not guilty, but there is already an issue because this is affecting your life. And that can range from the rape and sexual assault, and of course at my firm we deal with complainants as well as suspects. And so sometimes, for instance, with complainants, it's about helping them make a decision about whether and how they want to deal with that experience. And so because somebody has had this experience doesn't necessarily mean that the right answer is to go to the police. Or maybe it's not the right time to go to the police. I had a woman last year who wanted to send a message to her abuser. And there was a legal path within which I could do that, which says, you know, I don't want to hear from you anymore, stay away from me. So a kind of cease and desist letter. But actually, before she sent that, I wanted her to satisfy herself that she understood all the options in front of her. And she'd never spoken to anybody about this abuse before. And that she'd satisfied herself of all the options in front of her before she sent that letter, because if she sent that letter, it would have an impact on what a police investigation might look like. I just wanted to satisfy myself, completely selfishly. But again, that's a way in which we ask therapists to assist us. And then you've got, I do a lot of views, so there's the whole porn and sexting, and it goes on. And so therapists help me understand what the motivation is for a behaviour, so that I can explain that to somebody else. Last year I dealt with just a lovely young man who had set up a fake Instagram account and pretended to be a 16-year-old girl, was sending messages to another person at school. This is actually a really serious offence. Really, but he didn't know that. He thought he's pranking somebody. Really straightforward, and as you know, with views, within a matter of minutes, we're talking about sex. And so that conversation then became a very serious offence. And so when it was found out, and I've got all sorts of assessment. I've had a maturity assessment done, I've had a psychosexual assessment done, I've got an educational psychologist involved. All of these people are saying, this is immaturity. We all know, don't we, young people's brains don't actually mature till they're about 25. No, the criminal justice system doesn't see that. It says it's an offence. Anyway, prosecuted, couldn't stop them doing it, offered them all sorts of options, but they did prosecute. Do you know, it broke my heart. About 3 months ago, his mum contacted me and said the social worker who'd been involved, who was saying, no, this is a very dangerous young man, a year and a half on, says that actually she agrees with you. This wasn't about sex. It was maybe bullying, and it may be immaturity, but it wasn't sex. It's too late. He's already got a sex offence on his record. But what you helped me do, obviously in that case, not as successfully as I had hoped, but that process is really important for our work. And so a range of behaviour. And so where are the pinch points in terms of us doing that? So I do it pre-charge, as I've explained, during trial, really good support in terms of helping a client through the criminal justice process. So I had a client who was accused of rape, acquitted in the end, but that process, which takes about 2 years, somebody to hold him emotionally while I got on with the law, was really, really important. It kept us all sane. So that's one of the times that we use during trial. Obviously expert evidence. On conviction, in terms of mitigation, as I've described, or pre-sentence report, I can often use the report, a forensic report that's been completed by the therapist for the youth offending team or the probation service or the court. And then post-conviction in terms of prevention and compliance with any orders. How are we doing for time? We haven't got much time. There is so much more to say. I'm just going to consider the really important bits related to that, which have for me about communication. The therapist that I work with, I grow to trust, and that becomes an integral part of the team. I know that there are issues there about boundaries, that what's confidentiality means to you may be slightly different to me, but the importance of us talking about it and how badly it can go wrong if we don't do that. And the importance really of me being clear with my client about our conversations being covered by legal professional privilege, but hoping also that you as therapists will be really clear about what your boundaries are. And Julie's already spoken very eloquently about what you have to do from a statutory perspective and what you feel you ought to do from an ethical perspective. Being really clear with clients, particularly when you're dealing with this subject matter, is a really important part of being able to continue to work together and provide the best that we can for our clients. I think probably given the time, that's as much as I really need to say for the moment. But if we have anything in Q&A or later on, please pop in and have a chat.
So there really isn't very much time, so I am going to cut the jokes, cut the war stories, so I'll leave probably. Where can I start? My initial thought when I was going to give this talk was that we're connected in lots of different ways. We face the same regulatory, practical and moral considerations, and the same dilemma with this. You and us, we're very similar in lots of ways. What we have to think about is how to do the right thing by our clients, how to do the right thing by our regulators, and how to be ethical in the way that we practice. And in my view, there's only two things that get in the way of that: ability and money. So I'm going to talk about being a divorce lawyer and how I engage with your community, how I think about myself, and what role I play in this, and how I abide by the rules of my regulator. I want to say that there's some similarities between us, and at the end I'm going to share some rules that I work with. You don't have to follow them, probably won't. I was going to tell you a story about one of my clients who died last year. I won't, but just to say that in my view, when addiction comes into my working life, it's like one of those old horror films when someone is possessed. It's something quite evil, and it's very difficult for us. And I echo Sandra's words that we need you as much as you may need us from time to time. So when I look at my work with addicts, I ask myself some questions. My competence to act, what is that? What are my motives for acting? And what do my regulators say about it? You're lightweight, you're fired. Can't quite remember what that was connected to. I think it's probably just that. Don't be scared. Your client may fire you. I am not an addict. Unhealthy relationship with my telephone, friend, muse, lover, whatever. I watch a lot of Holby City, but I'm not a surgeon. I'm not a therapist. My only gag. What's the difference between a lawyer and a therapist? About £250 an hour. I have, however, acted for lots of addicts and their spouses over the years. I understand the challenges and the lives that they lead, know how dangerous it is out there, and mostly I know you. I have people to turn to, people I can inject into my working life. What are my motives for doing this? I struggled with this a bit, and then a couple of weeks ago someone told me, they said, in your community, they said, the only people we refer to and cooperate with are people who give a shit. And so I decided that was probably me, the divorce lawyer who gives a shit. I tried to sell that to our marketing team as my new brand. Someone pointed out that gives could be replaced by is, but it might not be such a good idea. I said, no joke, sorry, I'm wasting your time. My regulators, my relationship with the regulators are contractual, and my clients are contractual and legal. I've got conduct obligations. I'm free to accept instructions, but I need to think about some things before I do so. My regulators say that when deciding whether to act, I have to be sure that I have the resources, skills and procedures, whatever that might mean, to carry out my client's instructions. Some of the ways that I can be sure that I'm fulfilling those obligations are to have connections in your industry, lots of them. I'm independent, totally. A willingness to engage and commit, something that's going to be emotionally draining. I think that falls into the give a shit category. My team have just engaged with a therapist to give us support to do MOTs and roadside assistance so that we're all supported in the work that we do, which can be pretty intense. I know they need to know when I'm out of my depth, and I've got to have sufficient time. However, most people who come to see me who are alcoholics don't just rock up and say, I'm Brian or Belinda, I'm an alcoholic. It usually comes in some way down the line. I'm hopeless at recognising an addict. I'm brilliant at recognising a codependent. Mandy Saligari taught me how to do it. There's an observer book of codependence. Being a divorce lawyer with addiction, I've got a slide with this as well. Ambition, that was another one I missed, and that was another one. Don't forget to be awesome. And regulation. That's quite good, that, isn't it? A bit serious, but very good. There we are. Get ready for a wild ride. When an addict comes into my life, that's what it's going to be like. Divorce is very tough. The burden of addiction makes it harder. The lawyer's job is to achieve the best financial outcome for their client and the best interests of a child. With the addict, this is going to be juggling quite a lot. You've got a husband, also an addict, who's hell-bent on killing themselves, and the non-addict who is quite determined to protect children from risk. Addicts don't seem to accept that there is a risk, and the problems go on. Money is something else. Very broadly, wealth is shared on divorce, and if there isn't enough capital to provide an income stream and a home, then it's possible for one of the spouses to have to support the other. It is bonkers for an addict to be given a whole load of money, it seems, but that often happens. There are steps that you can take to protect. The court of protection could step in if someone's incapable of managing their own affairs. It's very rare. The ideal situation would be a conversation between all involved, lawyers, therapists, clients, before it all kicks off. But it's usually too late by the time people get to me. As I say, denial is usually at that point, sitting in the last chance saloon, having broken all the windows and the mirrors. Conflict of interests, we've touched on that before. I quite like this slide, and just look at that surgery. I mean, it is breathtaking if you could see it. I mean, anyway, there's a little secret I need to tell you. Lawyers make money by sending bills to their clients. Lawyers have targets. They have to make a certain amount of money. Their careers may depend on it. Their promotion as a young lawyer will depend on them reaching financial targets. They are conflicted all the time by the need to make money. Will the average lawyer, who has no ability to deal with an addict, turn that addict away because they have no experience? Probably not. They'll suggest to themselves that they probably have legal skills that will get around it. They believe that a client has a right to representation. They're family lawyers. We're in the empathy business, and so that should just do the trick. The reality is that lawyers just won't turn away work that might have an impact on their pocket. There'll be a self-interested rationalisation that the problem will either go away or they can deal with it. My fear in your industry is of the cynical minority. Addiction is a chronic reoccurring condition which comes face to face with a really sophisticated, slick cure industry, which is fed by persuasive, articulate people who are some of them who are in the pay per click, per bed, per referral business. I find it really, really difficult to see how families, trustees, lawyers can be sure that the best interests of their clients can be guaranteed in that kind of world. What makes it worse for us is that our clients are often not aware that there's a financial connection between the therapeutic unit and where the treatment is going to go on. I think that has to be wrong. The sophisticated families out there, the family offices now are employing therapists to be their people, to be an interface so that they can guard against inappropriate or the wrong kind of treatment. So far as I'm concerned, the relationship between the lawyer and the cure industry has to be built on trust. Fee sharing and referral fees are wrong. Trust and independence is compromised. If I accepted a referral fee, I'd be sacked. Clients should be in a position to make an informed decision about how to pursue their case. However, it's not all gloom. Good ethics is good for business. This firm, Kingsley Apley, it's plugged, but it's real, have made their reputation through integrity, confidentiality, and independence. And it's a 40, 50 million pound a year business, and it runs on those wheels. Our managing partner was recently interviewed by the legal press because one of our consultants was found to have attended the notorious President's Dinner. It's being recorded and filmed. We'll go too far. It's public. She said he's no longer with us. It lasted about 24 hours. That's the sort of integrity that I'm talking about. So no apologies for the scold. What I thought I would then do is give you some of my ideas about how I practice law comes from the Politics of Ecstasy, Timothy Leary. Hands up, anyone who knows who Timothy Leary is. Yeah, I know, it's age. I think that's the thing. I thought it was so turn on. Enter with caution. You may not be the right professional for every client. Have your codependency radar tuned to high alert. Be alive to your own or others' inherent conflicts of interest. Engage and activate your therapeutic alliance. Get consent to speak to wider family. Establish trust. Tune in. Still doesn't mean anything to most of you. Awful lot to me. Establish trust. I was going to take my tie off, but I can't because I've got a microphone there. Sometimes that's the way to do it. As a suit, it's quite difficult to persuade clients that I am nothing but someone from the outside looking in. I've got to realise there's a lot of secrecy and concealment going on. I told this before. I had a client whose wife died drinking. He rang me one day, sometime afterwards, and said, "It's autumn." I said, "Yeah, sure, it's autumn." He said, "The leaves have fallen off the hedge." I said, "Completely, they've fallen off the hedge. It happens." He said, "That's where she hid her bottles." I have to give greater thought to the sort of approach I have, and I've got to guarantee confidentiality and pity the children. Children don't choose their parents, and the chaos that addicts cause during divorce and to children will continue for a long time. So the lifetime of the relationship needs to be given some thought, again, where I need you or where I try to engage you. Then drop out. Timothy Leary said that this didn't actually mean get stoned and abandon all constructive activity, but self-reliance, a discovery of one's singularity, a commitment to mobility, choice and change. It's a kind of constant process of personal development. For me, it's representative of the challenges that I face working with addiction. Learning way out of my comfort zone, adapting and trying to persuade other people in my world that addiction can be approached with some hope and positivity, making the right therapeutic connections, and above all, creativity. I'm dealing with something unusual, there's going to be unusual solutions. For you, perhaps, looking honestly at your responsibilities, looking honestly at your abilities, being independent and free enough to know when something is not in your client's interest, and then recognising finally that good ethics can mean good business. And I think I'm done. We're hoping for some questions.
Hoping. Yes, we are hoping.
If there are any. And can you use a microphone? Can you use a microphone?
Thank you very much. A couple of things. One, thank you for mentioning referral fees. If there's something that's going to make my blood boil, that is it. I get rather fed up with people offering me, come and see my facility, and if you send us a client, we'll give you $4,000.
Yes.
I just have a no policy on that. But the other thing I have, as a sex therapist for the last couple of years, around what might potentially happen if you had someone who was being prosecuted. The one I have in mind, he was being prosecuted for, I think it's known as upskirting.
Yeah.
And as it turned out, and my suspicion, he was definitely looking for a little letter to say he'd tick some boxes before sentencing. Is there anything around, my notes generally are very, let's call them poor, but very vague and bland, and talked about mum, dad, and nothing in particular incriminating or anything. But is there anything in particular I should be wary of when working with a client like that?
Were you engaged to treat, or were you engaged to prepare a report for the purposes of the criminal proceedings?
He asked for a report on our first session. I'm a therapist, I'm not a psychiatrist. I'm not able to say whether he's likely to reoffend or not. And I said that right at the start, I made it clear throughout our sessions together. We saw 6, 7, 8 sessions until he was pleading guilty. He was sentenced, and I never saw him again.
So did you prepare a report for the court? No. So
I wrote him a letter to confirm he had attended 6 sessions.
Yes. So it seems to me that your engagement was confined to being a treating clinician.
Yeah.
So you ought not to be looking out with your contractual relationship with your client. You know there's a bigger picture, but actually you need to make sure that you're competently and proficiently and compliantly treating him. Whatever he chooses to do with the product of that is a matter for him. I suppose it will inform the way you deal with him if you think it's a construct, if you think, that might form part of your treatment with him. But I don't think there are particular red flags or particular things that you ought to be thinking about, because you're not engaged for that purpose. You're not engaged as an expert to prepare a report. You're not thinking about attending to give evidence, disclosing notes. So I think in that particular scenario, you're quite myopic, aren't you? You're as a clinician.
I mean, it was my anxiety of
Yes.
the judge is going to call me on the phone and drag me in.
Well, I mean, Sandra will know more about the likelihood of that happening.
So different sort of factual matrix might result in that situation. So for instance, if you were treating somebody who was potentially a complainant or a victim, as a defence lawyer, I would do everything I can to get hold of those notes, because those notes will have useful information. And so it's that sort of area that you want to be sort of mindful of. And one of the slides that I skipped over was about how you record, and you mentioned it, Julie, how you record things, where you record it, how contemporaneously you record it. These are decisions that you need to make very early on, thinking, okay, I'm doing this for this particular audience, which is this client and treating them, but there may be a criminal justice audience for this information at some point in the future. So what do I need to include in this note? And maybe perhaps separating those from this client's notes, this patient's notes, from my aide memoir for working with this person. Those are two different things, and well worth thinking about them very early on.
I have a diary, and then I have my client.
That's it, there you go.
And actually thinking about other audiences, we also act in coronial processes, and the coroner's court have the power to get your notes. And it happens a lot, and I represent therapists at inquests, and it's excruciating when your notes that you thought were private or that are incomplete or that contain your musings or terribly, terribly personal stuff. The coroner can redact, but they don't always. And so thinking about the content of the notes and how complete they have to be for your current audience, but also occasionally for your future audience, it's not easy.
Hi, yes.
Hi.
I'll do 3 questions in 10 seconds.
Okay.
Quick. And you can pick which one you want.
Okay, good. Seems fair.
So the first is maybe more for you, but the role of the SFO, the Serious Fraud Office, right, and the Insolvency Service as vis-a-vis the regulators. Because, for example, when you look on the government's website, it says if you're worried about the unethical behaviour of a British business company, complain to the Insolvency Service. Or if it's very, very serious, the Serious Fraud Office. The second question is about doctors, nurses, and psychoanalysts, regulated professions in management positions who might become aware and be able to influence unethical behaviour, but are not directly, as a doctor or nurse, partaking in it. And the third question is about judicial reviews. Probably quite an easy question. Does a judicial review look at the work of more than one regulator dealing with an issue? If more than one regulator is not, helping to address or deal with an issue, like the ones we've discussed.
Sandra's question 1, and I can probably do 2. I might be able to do 3.
I quite fancied 2 actually.
Oh, go on then.
If that's right. But just under the Bribery Act, there are offences which have to do with failing to prevent bribery, and I don't know whether you were thinking about it in that context. So a manager or an organisation can be guilty of the offence because it hasn't put in sufficient safeguards, procedures, policies that prevent that kind of behaviour. So that would be, I don't know if that helps.
And regulators take the same view.
Yeah.
So they will often bring allegations. You see it a lot for social workers failing to supervise the staff and their mandatory Children Act visits. So those at the top and those on the ground can all be responsible for the same factual shortcoming, same pleaded shortcoming. They do it quite a lot.
And I've forgotten question one.
With the insolvency service and the SFO, and when they get involved in what they do, 'cause they,
I mean, I couldn't be precise about the delineation between the different organisations, but what you have is culturally at the moment lots of people fighting to prosecute new groups of people who, we are all in the business of helping. That is the predominant reason why we do this. We're all very well educated, we could do different things for a lot less work and on more money. We are trying to help, but regulators and those kind of law enforcement agencies, they have an appetite at the moment. And so I guess the message is, let's think about it from that perspective. But which one comes for you, I don't know. But let's just put in procedures that are going to, you can never completely proof yourself from these things, but you can put yourself in a better position to give an explanation if one is required.
Dominic, I'll come to you afterwards about your JR question, one, because I didn't understand it, and two, because it's 1 minute to one, and I think this lady here had a question.
Okay, so I'm actually accredited to the Federation of Drug and Alcohol Professionals, which is something you haven't actually mentioned.
Yes.
And I want to know how much weight a verbal contract has with a suicidal client.
Well, that's a question to end all questions, isn't it? So your verbal, your pact that you at the end you say, right, you're not going to see through your suicide plan. You're going to take this step and that step.
Yeah. So basically, I have a client who'll come in saying they're very, very depressed,
Yeah.
and I have to obviously ask them any suicidal thoughts or ideations,
Yeah.
and they say yes.
Yeah.
So I, at the end, will say, okay, we need to have a verbal contract.
Yeah.
That if you do plan on anything, that you'll either call me or the emergency services.
Yeah.
And because of the way you're feeling, I need to get in touch with your GP. So
Yeah.
I cover myself as much as I tell the GP.
Yeah.
But it's interesting because if I was actually working with a client of yours, would I be obliged to tell you as well?
I have a therapist who I work with who has done exactly that. It's left me holding a baby, as it were. But at least from my point of view, we're very lucky. We've got very clear rules about what we do. But it was important and necessary that she told me. I think she told the client that she was going to tell me. Because it became relevant to how we then run the case in terms of when he gets information, how I will portray that, etc. The time of day that I will do it, so that there is an opportunity for a sequence of events to happen. But that's part of the agreement that I had with the therapist about working with this young person. And in fact, they were more forthright with her than they were with me, which is really interesting. Which is why it's really useful to have that extra pairs of ears and eyes that can be trusted. Really.
Are you asking whether you should commit that to writing, get the client to sign
Well,
it?
I just legally, I wonder where
Yes.
with all these new regulations and stuff in place, how whether actually it's not a legal contract, and if they then something did happen, whether.
I mean, I'm not a contract lawyer, but I understand that contracts can be made orally. So a contract can exist without a piece of paper to confirm its existence. So I think that's right. Caveat, not a contract lawyer. And as far as your regulatory obligations are concerned, any disclosure is discretionary. So you doing this, you breaching confidentiality, you're making a judgment to do. You've had this verbal dialogue, you've reached an understanding. You've probably committed that to writing yourself in the notes, the basis of the agreement. And you are being courageous, and you are making a judgment decision, a judgment call based on the known facts as they exist at the time, in good faith.
Yes.
What more could you do?
Well, if not much else.
Nothing more.
Yes.
Nothing more.
Okay, thank you so much.
It's okay. I think we should probably draw a line. Thank you all so very much. Thank you.